If you just dialed into this call, then just to let you know, we'll give it a few minutes for other participants to join, but we're gonna start probably 5 minutes after the hour at the latest. We have a lot of stuff to go through and not a whole lot of time to do it.
Maybe 3 minutes after.
You want to haggle?
Yeah, let's haggle.
Any other bits coming in?
I'll check LinkedIn, make sure nobody's having a problem getting in here. I don't see any messages, Chris.
Okay, T-1. And we're going to get started here. Good afternoon, everybody. I assume you're in California. That's why you're dialing in. That's why it's good afternoon, albeit I think Kimberly is still in her morning hours. Me and my friends are very interested in the intersection of data rights and privacy. Jeff and I run a podcast called YBYR Rights, where we discuss these topics on a regular basis in great nuance. And we figured it would be very useful for a lot of HR people in California, specifically at this point in time, to get an understanding where we are with California privacy rights and the new regulation that just took effect on January 1st. A little bit about my background. I was a software developer before I became a lawyer, and now I haven't been neither for the past 22 years. I've been focused on investing, mostly at the intersection of network technologies and data rights solutions. And so today you could call that privacy technology, fintech technology, a lot of different labels for that. Ultimately, for me, it's all the same as then what we're talking about is finally establishing property rights to data. So I'll give you the shortest history on how we have been treating data that you probably have ever seen. So let me share my screen from here. Here, my friends are going to be talking further, Colin, Jeff, and Kimberly. So I'm just going to give you guys a brief introduction to the topic. So I'm going to talk about the big picture and the future of privacy. Jeff and Kimberly are going to give you an overview of the law as it pertains specifically to California. And Colin's going to speak about litigation potentials. And we're going to summarize it with best practices for you guys. The big picture. We always have done commercial activity using ledger technologies. Actually, the earliest forms of writing, called cuneiform, which emerged about 3,550 before Christ, were clay tables and were ledgers. And then about 100 years after Christ, we invented paper solutions. And then in the last 60 years, we developed digital technologies. So databases were first created in the early 60s. And with the transfer of paper solutions to databases, we started over a period of about 40 years committing personal identifiable data and commercial activity to these database solutions at a time where you most of the time still needed hardware. Then some 20 years ago, we started to develop cloud infrastructure. And so we moved from digital data storage solutions to digital data transfer solutions, which is part of the issue that we experience today, because data storage solutions were actually not designed with the digital data transfer technologies in mind. And then we're going to talk just a little bit, because these are forcing functions to the adoption of new technologies, about new infrastructure, decentralized infrastructure, and they're specifically in the future and already emerging right now, digital property transfer, including anything that is your data. I consider that property. There's a data breach in the United States every 65 minutes. The only reason why this is going down at the end here is because there's always a lag in reporting. And on average, companies incur losses of about $9.4 million, according to the latest IBM research. So it's really a big problem. In aggregate, actually, if cybercrime was its own industry, it would make more than $6 trillion in revenues. So as a frame of reference, that's larger than most GDPs, with the exception of the United States and China. And then current trajectory would exceed $10 trillion by 2025 if we don't drastically change things. More of the same. Data breaches are increasing ever more often. It's actually doubled during the time where people started working at home. And a lot of agencies are now very interested in preventing and or penalizing the companies that are not handling data correctly, specifically as it pertains to personal identifiable data. And as we will see, and Jeff will and Kimberly will point out, as it pertains to employee data as well, which is a very wide definition, actually. For some companies, this might be the cost of doing business. Facebook paid a $650 million settlement to the state of Illinois for violating Illinois' BYBYR laws, biometric laws, and also paid a $5 billion settlement to the FTC for violating the FTC's consent decree of how this company is treating data. And there's a bunch of other fines. I taught privacy law right after law school back in Europe, which is about a decade ahead of the United States when it comes to data protection. So for these companies, this might be cost of doing business. If you're a small business, you're simply out of business. So from here, I'll let Jeff and Kimberly take it over and give you an overview of the law.
Great. Thank you, Chris. Let me share my screen now and do the present. Oops. It's not what I want to do. Sorry, gang. Okay. Can you see that? We are on the wrong slide, though, are we not?
We are back to the beginning.
Apologies. Okay. Hopefully we're in the right spot now. So thanks for the overview of the landscape, Chris. Not addressing privacy issues can have a regulatory consequence, security consequence, and even competitive consequence. We're going to come back to this, but let's dive into what the law says. In particular, we're addressing the California laws, CCPA and CPRA. Kim and I are going to sort of do this tag team. I'm going to do the first part. She's going to do the second part. Jeff Jokish, I work for Privacy Plan. That's my company. I'm an independent data privacy researcher, and I create a lot of data sets around data privacy, whether that's privacy laws, privacy regulators, privacy podcasts, and a variety of different things. So I essentially do the research trying to figure out what these laws say and where things are going. And where they're going is, is essentially in a way that's making it more and more strict for every kind of business, whether you're a large business or you're a small business. And what's happening in California is it's really sort of moving more toward what the European model is, but with some differences. So let's look at actually what's happening here with this change. Now, when CCPA passed, it essentially covered employees, but that coverage was delayed. And now with CCPRA coming into effect, it's actually in force. So who's covered? For-profit entities that do business in California, processing workers' personal information if one of these other three things are met. Reasonably large companies that have 25 million or more in gross annual revenue, or if you cover personal information of 100,000 California residents, right, that buy, sell, share, or receive that information. This could be, just simply a high traffic website or app. Or if you get more than 50% of your revenue from the sale of personal data. Now, normally we would think of that as a data broker, but as we're seeing with some of the new decisions by the FTC and by some of these regulatory agents, that could actually be different depending upon how that's interpreted. The sale of personal information could actually be like sharing. So you have to really think about whether you're covered by this law, and determining coverage is a lot more complicated than you might think if you're just actually reading this for the first time. So if people have questions about this and you're not sure whether you're covered, you probably need to go to a privacy professional or a lawyer. And we can certainly talk a little bit about this in the Q&A if people have questions. I'm going to go ahead and go to the next point. So the first sort of insight, we talked about sort of having 9 insights here. The first insight is entities who think that CPRA doesn't apply to them really may be wrong. Digging in a little bit deeper here, who is actually an employee? You think you know who an employee is when you talk about employees in an organization, but employees in this particular context is much, much broader. In this case, employees are actually workers, past and present, job applicants, independent contractors, officers of your organization, directors of your organization, medical staff members, even emergency contacts and beneficiaries that are on policies. So this actually covers a wide variety of entities that you have to think about. And it's not particularly easy for a lot of people, including HR folks, to consider this when you think about, okay, now we just have to cover employee data. So it's actually a lot of things beyond the norm. Oh, sorry. So the definition of employee is much wider than most professionals realize. So let's think about this actually for a second. You can have a past employee asking you to delete their data. You might have a current disgruntled employee asking for all of their data because they want to litigate. Colin's going to address this in a little bit. You can have job applicants asking for their data after you deny them a job. You might have your vice president of finance's daughter submitting a DSAR request because she's the beneficiary on a company life insurance policy. Or part of that beneficiary. What happens when somebody wants to delete important data, and do you know what you can and cannot delete? You even have the ability to delete that data. And it's now required by law, and so this is sort of an important question. What happens when personal data of one person is mixed with the personal data of somebody else, like in a Slack conversation? All these things start to get very complicated when we think about DSARs in the context of employee data. So let's look at a little bit deeper here. What can employees actually request? I started to get into some of that. So essentially, the DSAR requests of employees are very similar to what a customer can request. They can request access to their data. They can request deletion of their data. They can request correction of their data, because the law essentially is now saying that employees have the same rights as customers have, okay? And I'm not going to go into all of that, right? But there are some exceptions to this, right? Because employees are actually different than a customer, right? So the exceptions that you might want to think about here are these, right? So the right to delete applies to information that is collected from the individual. So if the information was not collected from them, you don't necessarily have to delete it. If they gave it to you, chances are you might have to delete it, but if you generated it, there may be some leeway there. Second thing is, an employer can refuse to delete information if it's necessary to comply with laws applicable to that employer, right? So if you have a legal responsibility to keep that information for HR retention purposes, for instance, you don't have to delete it, right? The organization can also refuse to delete information if deleting that information would prevent the business from exercising or defending their own legal claims. So there are a lot of reasons, and there are probably more, but those are three of the major ones that you wouldn't necessarily have to delete information. Employees can also ask to correct information. And this has some nuance as well. We're not going to go into that, but there's sort of a totality of the situation that you need to think about when you think about employees requesting to correct information. So what else can they request? They can request to do not sell or share information. And that includes having the knowledge of who that information is sold with or shared to. And they can also ask you to limit the sharing of sensitive personal information. This is actually sort of important, particularly in hiring situations, if you are using any kind of automation for your hiring. So if you're using algorithms to figure out who to hire, or if your vendors are using those kinds of algorithms, then it's probably processing some kind of sensitive information, and employees could potentially ask you not to do that. So you need to be careful of this. Finally, there's a right against discrimination and retaliation. So you need to be aware of that as well. So if they're asking for any of this information, because they asked for that information, you cannot discriminate against them because they asked for to exercise these other rights. So all of this information, all of these rights are talking about specific pieces of information, but what kind of information is that? So what is the employee data we're talking about? So this is essentially personal information, but employee data is a little bit different. So name, date of birth, email, phone, address, contact information, right? But in the context of employee data, this would also include performance reviews, interview notes, resumes, cover letters, resignation letters, termination, documents created by an employer, another employee, the employees themselves, right? But there are gray areas. What happens if it's email records, presentations, videos, right? The law is not clear yet. There's probably going to be case law that comes up that sort of defines this better, but right now we really do not know. So we're going to have to sort of see what comes of this. And with that, I'm going to hand this over to Kim to take us forward on what to actually talk about once we sort of understand these particular requirements. There's lots of detail that I probably could have went into, but I wanted to sort of keep that a little bit short. There's, one other thing I could actually say sort of about what counts as employee data. When we talk about this, we can actually go into sort of like talking about sensitive personal information. And there's a differentiation in the California law about sensitive personal information and regular personal information. So you do need to be aware of that. And we can talk about that a little bit in Q&A afterwards. But I want to go ahead and hand this off to Kim.
Thanks, Jeff. I really appreciate that. I'm Kimberly Lancaster, and Jeff, if you don't mind, we'll just keep your slides up, and that way it's a smooth, easy transition for everybody.
Sure.
I'm a senior privacy manager, and as part of my daily job, these sets of questions have come up. So I was very happy that I was asked to participate in this, because it is something that everybody needs to think about, because you don't think that it applies to you until it's too late, and then you have problems. Really what it comes down to is that, as Jeff talked about the DSARs, GDPR, it was 30 days. CPRA gives you a little bit longer. You can go 45 days. You can go up to 90 days if you have provided some explanation and you have, it's a complex request. As Jeff said, when we look at a DSAR, even if it's asking what information is stored or processed by a company, that may take time to go through and identify everywhere where that employee's data is housed and processed and everything else. So if you need to use the full time, but the one statement I would say is be upfront with the employee or the former employee that's asking. Let them know that you may need to take longer than the 45 days and that you will keep in touch with them. So if you deny a request, you have to give reasons why. That's a big piece there. And I think Colin's going to go into that just a little bit more in his section around, some of the situations when you would. So Jeff, if you don't mind, jump into the next one. Okay. You must give your employees a notice. You should have a privacy policy. You should have a notice of collection when you're collecting data. So just like we do with our customers or with your customer data, you have to do the same for your employees. You have to give them notice and the ability to ask questions or say, why are you collecting this? Now, when we talk about what it means for an employee, if they are, you're a new employee and you come into a company and they use, an email client, they use a communication client, they use, a different, they have an office suite type of product. In your onboarding, make sure that they understand that there's going to be information collected about them, whether it be as simple as their name, their email address for work, and what they do at the company that may go in that. Now, when you're talking about HR tools, of course, you have more data. So you do need to show that you're giving consent and that you are putting a notice out. I can't stress that enough. A lot of companies do an external privacy notice. You really should have an internal privacy notice telling your employees what you do with their data and how you do it. So, Jeff, if you don't mind going forward, what?
Hey, Kim, one
Yeah.
question.
Yeah.
So, HR collects information in a lot of different points, and we spoke earlier about job applicants. So
Yeah.
if somebody's applying for a job, should we be notifying them that we're collecting information?
Yes. So great point, Jeff. Anytime that you are collecting personal data, whether it be a recruit, a prospect, you've reached out to a possible person that you want to apply, having them come in through your recruiting process, that should also be, you should have consent there, and you should have a privacy notice there as well. So an example is some companies use different front ends to provide that recruiting information. That company that you're using, that vendor that you're using for that, should have the ability to allow you as a company to provide a privacy notice, or they should have a privacy notice of their own. And in there, but the aspect is that you still have to handle that data appropriately. You still have to give them notice of what they're doing and why you're using it. So if you're collecting sensitive personal data, what's the purpose for it? How are you going to store it? Everything. So yes, great call out. Okay. DPAs. I know that DPAs sometimes make people pull their hair out or make it fall out, but it is something that is critical for the CPRA and for businesses. If you don't use a DPA with your currently, I would highly suggest that you contact a specialist or a lawyer, or use your internal resources to definitely get one set up. The DPA provides a lot of clarification and ability for users to really drive down and provide clarity on how and what data is being used and what controls are in place to protect it. Under CPRA, a business that sells or shares personal data of a consumer or worker with a service, you've got to have a DPA. So, good example of this. You're a company, you have a vendor that you want to go use that provides a set of services for your company that allows your employees to give recognition among one another. Having a DPA in place with that vendor is critical so that you can ensure that they're going to follow the same level of controls and the same level of protection of that personal data of your employees as you would yourself. So making sure that you have things in place is critical. I think the other aspect here, and Jeff, if you want to add in anything, please feel free, is making sure that those DPAs are consistent, that you're using the same format, that you're using the same level. Your customers are going to ask you to sign a DPA. They want you to pass that on down to your sub-processor or to your vendors. Make sure that you're doing that. And then let's go ahead and go into the insight. And I think, who's an employee? Okay. Sorry, my notes are catching up a little bit here.
Oh, no, that was just sort of.
That's the insight. Yep. Okay,
yeah.
Perfect. All right. So yes, have your DPA. Much as the lawyers on this call will understand that they may think they're fun, the rest of us don't. So, but they're a thing that have to happen. So let's go ahead and jump to the employee training. CPA requires a training. You have to make sure that you have training available for your employees and resources available for your employees to know how to handle, what to do, how to respond, and making sure that you have they're clear and clean and crisp. You can't make them very vague, and you really have to be concise. You have to also be very concise, and I'm going to tie this back to the DSARs. When a possible recruit that comes in and says, I want my data removed, you have to be able to answer that process properly. And to do that, you have to have the training. You also have to understand all the requirements. Now, there's some great resources out there. We've got one listed here about what training is required. Definitely take it into account. Take the time to put together some documentation. Take the time to discuss it with your employees. And it's going to be the majority of your employees, if not all, that are going to need this training.
One thing to add here. So
yeah.
In California, the law essentially says that people have to ask for their data subject access requests in particular ways, whether that's email or through your website or things like that. Yep. So you do have a little bit of leeway there. You can train your employees to look in certain places. But when you extend that to other laws, they're going to have different rules. For instance, GDPR in Europe, you can ask in virtually any way through any medium to exercise your rights. And so if you're covered by GDPR, your employees have to understand how people can ask in a myriad of different ways. And other laws are going to be implemented very similarly. So your employees have to understand what privacy rights are and how people can ask to implement those rights.
Exactly. That's why having documented processes having training and having reinforcement on that training is critical for your employees that do DSAR work and for others in the company, so they know how to direct calls or questions or other things. It's amazing, somebody in product gets a question and a request for a removal, and here you go. So yes, insight number 4, employees need training, and it needs to be reinforced, and it needs to be easily found in your internal systems. They need to be able to go to whatever you have.
Absolutely.
So, okay. And come on, get over here. Enforcement. Okay. Oh boy, will they come out with swinging and fines? Well, it's been a great big uptick of GDPR fines. So I would say it's a possibility. I do think that they're going to have a lot of review happening. And it is something that you do need to think about. When GDPR went in, a lot of companies went, well, okay, it's over there. They're not going to bother me. They're going to go after the big boys. Well, now they're starting to come after, smaller companies as well. So it's really important that you take this into accountability when you're thinking about your strategy as a company and what are the things that you don't want to have happen. And, making the statement to a regulator of, oh, hey, I didn't know this was for me. I didn't know this applied to me. That's not gonna fly. And it's gonna make, the conversation very, very difficult. Some of the fines are pretty good. It's $2,000 per offense for mistakes. It's $2,500 per offense. And that doesn't mean just the time they come in and find it. That's per number of incidents that they find when they're in there. So if you have 500 employees and you haven't done something, that's 500 times 2,000. It starts to add up pretty quick.
Yeah, absolutely.
7,500 per offense for willful offenses. That hurts. And the one that I want to call out, and this is really important, there's an automatic $7,500 fine for violations of minors data, and that's children under the age of 16. It is, Jeff gave the example of the beneficiary. This is critical stuff, and it needs to be addressed appropriately. And that's why it has to roll up to your management and be part of the company awareness and strategy of how to become more mature and how to become better. And with that, hand over to Colin.
With that, we're to Colin. Colin, take it away.
Yeah, if you want to switch off, I'll share my screen. Hello, everybody. Hope you're doing well today. My name is Colin Walkie, and I'm an attorney in Oklahoma City. I'm CIPP US certified as well as CIPM certified. And today we're going to talk about the litigation aspects of this, because one of the things that Kimberly mentioned that I think is really important for everyone to understand is that the buck stops with HR when it comes to these issues. So some of you may be aware of the fact that recently there was a $250 million judgment rendered against Burlington Northern Santa Fe as a result of violating Illinois' biometric information privacy law. And the reality there is that the rules were pretty clear that they needed permission and consent from the employees before they collected biometric information. They did not. And I'm willing to bet the general counsel for that company is now really regretting not making sure they were on top of this. And so this is really something where HR needs to take the lead and be prepared for litigation. So in that regard, let me share my screen and we will talk some details. All right. So with regard to litigation, first and foremost, as Kimberly mentioned, mapping employee data is not optional. While the law may not explicitly say you got to go out and map all of the data that you have, As a litigator, what I can tell you is that my first step in any lawsuit is to find out what were you supposed to do? And there is no way that you can respond to a data subject access request if you don't know what information you have on those individuals. Worse yet is that data mapping isn't a one and done type scenario. The only way that you can know whether or not you are still abiding by your policies and procedures is by doing routine maintenance on that data mapping. And that shows you the gaps between the data maps that you have and where you eventually went to in 6 months or so. Another thing is that if your company isn't necessarily required to comply with the CCPA today, you need to be thinking about down the road. Because I think in all reality, some form of a national data privacy law is going to be coming down the pike. And if you haven't encouraged your company to start today, then they're going to have a lot of technological debt built up over time that's going to make it even more expensive than if you would have started today. So you've got to find out what you should do is my job as a litigator, and that is that you should have data mapped. The second thing is I'm going to find out from your own policies and procedures or the absence thereof what you should have done, and then I'm going to use it against you. And then finally, I'm going to get a settlement or a judgment for a 100% preventable offense. And so the reality is that data mapping is kind of your starting point for all of this, and that shows you the importance of it because you can't produce and respond to what you don't know you have. Another thing that HR professionals are pretty well aware of is BYOD policies, bring your own device to work policies, especially in light of what has happened since COVID. Hold on real quick. I went too fast. Sorry about that. So more and more employees are starting to utilize their own phones, but companies' best practices should be company supplied phones. And the reason why that is because that gives you control over all of the data. If somebody quits today, they can't take it with them. You get to shut it down if it's your device. And if it's not, you need to make sure that those personal devices that individuals are utilizing only store company-related data in certain areas with data segregation. So understanding what information your employees have on their phones and tablets and other devices is part and parcel of this process. Another question is special categories of information. So those pertain to things like race and gender, et cetera. And so if you're talking about race, there are certain EEOC reporting requirements that HR professionals always respond to, et cetera. And so then the question is, well, can I use that same data for diversity and incentive programs? That may be a great idea, but if you're going to, you need to make sure you get consent for obtaining that type of data and then using it for those purposes. You can't just take their information from the moment they apply for the job and then they get the intake and they're done and then start using that information for an alternative purpose. You need to make sure that's within the scope of the consent and the notices that you provide to your employees. Speaking of which, and going back to one of the topics that Kim touched on, with regard to notices to employees, can they be identical to consumer notices? I think in theory they could be, but best practices would be for you to have two separate ones. Why? Because you're probably not collecting and then utilizing the data for employees in the same form and fashion that you're utilizing for customers. So it's very important you have those two different policies, those two different notices for your employees. And then, oops, sorry, I hit the wrong button again. Dadgummit. So insight number 6 is going to be employees using data subject access requests to fish for information in anticipation of litigation. This is inevitable. It is going to happen. And unfortunately, we know that at least in the EU, they have said that the GDPR says that's okay. As long as they're asking for the information, they can get it irrespective of their motives. Now, what is interesting here, and going back to what Jeff touched upon with regard to what types of information can they get, you as HR professionals in California know that there's a separate statute that pertains to actual HR employee files and records. And what the CCPA and CPRA speak to are specific pieces of information. So does that mean that you have to give the whole email that has that individual's name on it, or just their name, i.e. their email address or whatever it might be? And obviously, as a litigator, I'm going to take the position, if I'm representing the company, specific pieces of information is your email address, your date of birth, whatever those sorts of things may be. It's not all of the content within those emails, et cetera. But as Jeff mentioned, that's yet to be proven out in court. Finally, or not finally, but as you all know, there is no private right of action for violations of certain aspects of the CCPA and CPRA, but there is a private right of action limited to breaches. And so if there is a breach, then individuals can sue under that private right of action that Kim was talking about as well, and obtain damages as a result of that. Just so that you know, there have been 270 plus CCPA actions filed as of September 2022. So if you think that lawyers and litigators don't see money sitting out there, you're wrong. And I promise you, we're going to get more and more of these lawsuits coming up the pike. Finally, insight number 7, you need a data retention schedule. What does that mean? That means how long are you retaining this data? Here's what the CPRA requires. It requires you to retain information no longer than necessary. Well, thanks for the specific information there so we can know how to build this. It depends on which type of data you have. Going back to the data mapping, in order to know how long you should retain information, you have to know what categories of information are stored and why you are storing them. So you could think on the outside, typically a 2-year retention period would get you past most statute of limitations courts. So maybe there's reasons to leave things alive for 2 years, but not everything. So you need to develop that data retention schedule and base it upon those categories of personal information to make sure you're not retaining more information than you need. So thieves can't steal what you don't have. Get rid of those social security numbers and passwords as soon as possible. Other things leave alive in the event of litigation. Whistleblowers. Yes, this law will increase the likelihood of whistleblowers. You could think about Frances Haugen from Twitter, et cetera. And more importantly, you can also think about the chief privacy officer or CTO that was recently convicted in federal court for essentially doing what management told them to do with regard to responding to a data breach. But what's important here is if that you're on the inside of this and somebody's telling you to do something that's not right, you can guarantee that somebody can be out there to be a whistleblower in order to get some form of a key tam action or compensation. So what can the organization do to be better protected is have your chief privacy officer or have your chief technology officer report directly to the board. And maybe somebody within HR needs to do that as well, so that you're not caught up in management telling you what to do. And then 4 years down the road, you're left holding the bag for decisions that other people made. So with that, I'll turn it over to Jeff and Kim for best practices.
Great. Thanks, Colin. That was excellent. Let me share my screen and we'll keep going here. We are running out of time. Let's see, hold on a second. I shared in the wrong way again. Do we have a hand up? No, we didn't. Okay. We sharing or not? Sorry.
Not yet.
Trying to get this right. Share. Sorry, guys. What am I doing wrong here?
You want me to share mine real quick, Jeff?
What's that?
You want me to share mine and I'll just push through for you?
I'm just trying to get my notes up here. Yeah, why don't you go ahead and share, Colin?
All right, I'll share mine.
Stop that share. Okay, go ahead, you share.
Got it.
And I will go to my slide so I can see my notes. What is going on here? Okay. Sorry, guys. All right. So we're on employee DSAR best practices. So we're going to do this pretty quickly, but we've got a couple of different sets of best practices here. For DSAR best practices, the important thing here is to really create and these are very simple, right? Create a clear process, right? And flowchart it, right? You need to know how you're going to submit these processes. The employees and clients need to know how to submit it, but once they get to you, you need to know how you're going to submit it through the flow, right? And you need to understand what those communication flows are. So, for instance, when somebody wants that, sorry, I'm sort of blanking here. When somebody wants a DSAR to go through, who has to approve it? Who's going to gather the information? These things are pretty complicated. And if you don't map out every sort of eventuality, you're not going to get it right. It seems like it's going to be a relatively simple process until you start putting all the different forks in it. And then it becomes actually very complicated, right? Second point here. You want to staff this, but you want to staff it flexibly because your volume is going to vary. One of the things we learned when we started implementing consumer DSAR processes, even large companies, right, would spend like tons of money putting these DSAR processes in place, and then they would get like 5 DSAR requests or 50 or 100, right? But it wouldn't necessarily take wouldn't necessarily have a huge volume to justify the expense they put into putting these processes in place. And so you want to build a process and you want to staff it, but realize that you may have relatively low volume. So you want to think about that as you're building these processes. You definitely have to build them. You definitely have to staff them, but you probably don't want to have, a whole bunch of people staffed up on this full time if you're going to have relatively low volume, okay? Then you want to make sure once you've built it that you test it with various different use cases, because the things that are going to come in are not going to be normal. Everyone's going to be different, right? And then you want to make sure you educate your staff. And with that, I'm going to give it to, well, there's actually an insight here, right? So obviously you have to establish specific procedures in order to get all this stuff right. With that, I'm going to hand this off to the next one for HR best practices to Kim.
All right. Thank you, Jeff. As Jeff mentioned, DSARs are critical. Can't say enough about that. You have to be flexible in your process and understand that you will change as you go through. In the HR best practices, the one statement that I do want to make here is that in March of 2022, the California AG published a legal brief stating that under the CCPA, a consumer has the right to know internally generated inferences about that consumer. Data mapping, data classification, data inventory, and data retention, the 4 Ds, and that includes everything in HR. Use your ROPA, your record of processing activity, to understand stuff. It's critical. You really need to have the visibility into the data to be able to answer these questions properly. I cannot emphasize that enough. You also need to think about where in the normal course of a business that you're thinking that you're doing things that CCPA and CPRA are going to impact. Just like you did with GDPR, just like you should be doing anytime that you're collecting personal data, regardless if it's employee or if it's customer, you should be taking some additional thoughts around that. Again, coming back to the 4 Ds, they are critical to making things happen. And Jeff, if you are actually Colin, if you'll jump forward one. Vendors, here's the other one. I love vendors. I think they're great. DPAs are critical. Making sure that you do the 4 Ds with them as well. You understand what they have access to, what they're processing, how they're doing it. And above all, they aren't selling the data. Put it in your DPA. You're not allowed to do this. You cannot do this. Contractual requirements help the customer and help you make sure that these things don't happen. You really need to be careful. Do your vending properly. Treat it as a third-party risk management exercise because it is a risk. And I'll go ahead and hand over back to Jeff.
Thanks, Kim. All right. And so for our last set of best practices, they're training best practices. Your employees are going to need training. We've already talked about that, but what kind of training? They need training on your internal processes, these DSAR processes and other privacy and data and cybersecurity processes that you build, right? 3 different things, right? You got to think about internal processes, cybersecurity processes, data privacy processes. Not training them is going to cost you money. There's risks of fines, but more importantly, risks of breaches and poor productivity. Really interesting research out there that shows that security training by itself is hit or miss, but adding training and privacy training really helps employees understand why they should protect the company data and consumer data. So go ahead and go to the next slide, Colin. That's going to give us the final slide, which is insight number 9. Don't neglect your training requirements. And the reason you don't want to neglect them is a variety of reasons, right? Certainly there's the new privacy legislation we're talking about here, right? But there's also cybersecurity regulations that say you need to train your employees on this stuff. Also, probably your insurance policies, if you have any data breach insurance, they say you've got to do this training as well. So you have to do this training. And we think it's sort of crucial, right? So in fact, if you're interested, we're launching a GDPR Armadillo program to address that. But where are we now? We're on. So go back actually to the imperatives first before we get to that one. All right. So the imperatives, though, that we want to leave you with, right? If you can't do all of the stuff that we just went through this whole 53 minutes speaking to you about, right? Here are the 4 imperatives that you want to do. At least, if you can't do the whole 9 insights, if you can't implement every single thing that we talked about today, at least post a separate employee privacy notice. At least create a process to service employee DSAR requests so that they can do access, delete, and correction requests. At least update your vendor contracts to include specific CPRA provisions. And at least train your employees at least once a year, right? Those are the things we think that those are the imperatives. And then to come back to, go ahead and go to the next slide, Colin. The final thing, right? If you're going to train your employees, Chris and I are sort of putting together under this YBYR umbrella, something called YBYR Armadillo. And it's essentially a program to train and harden your employees. And it coalesces all of this privacy, security, compliance, and productivity. And it's risk, reward, ROI. Not teaching cybersecurity together with privacy to employees, we think is really just grossly negligent oversight. So we want to give provable training certificates to each employee that's going to save you money in case of incidents. And like Colin said, you know, you've got to do this training. And if you don't want litigators like him coming after you, we think we can help. So with that, I'm going to turn this back over to Chris. And you want to do the last couple of slides?
Sure. I mean, we really only have one, but as I indicated in the beginning, if we were taking part at the beginning of the call, we got into the scenario where third parties hold your data in databases that cannot be protected. And you've probably been at some point in time through TSA and they patted you down and they made you take your shoes off. And in a way, that's kind of what's happening in the cybersecurity space, where there's an assumption that all of these solutions that companies are paying for are actually protecting you. But the problem with that is 80% of the time, that's not how intruders are actually getting to your data, but 80% of the time it's your employee who is being spearphished or otherwise compromised, giving his credentials away. So all these other things that you're seeing here that you're paying for at that point in time are utterly useless. So point that being is, and Jeff is exactly right, what we do at the fund on a daily basis, we review solutions for the viability, and they're specifically data solutions. And from our perspective, a solution is not viable if it's still exposing a large amount of personal identifiable data in any shape or form. Anything that you're committing to a database is basically stolen. And according to IBM's research, 83% of US companies will be breached in the future, 83. And for a lot of these companies, that means game over. So we are investing in solutions that will prevent this in the future, but they are not quite ready yet. Albeit, you're going to be actually responsible for being able to interact with government-issued solutions that already protect this data. So there's already 3 states out there that issue digitally native credentials. You hold these on your enclave on your iPhone. Actually, it's 4 states. And so you as HR person also need to think about, how are you going to deal with these new credentials specifically? And Daniel from the audience has raised his hand. Let me give you the microphone and you can ask a question. Let's see how I do that here. Where's Daniel? Attendees, Daniel, allowed to talk. Daniel, what did you want to ask? You need to unmute yourself though. Still muted. Okay, maybe Danielle was just waving goodbye. Anyway, so like Jeff said, for the past, what is it, 6 months, we've been interviewing vendors in the space, specifically through our panel and think tank of cybersecurity researchers, privacy researchers, lawyers, and whatnot, for the viability. And we found out that 80% of them are useless. So that's why we kind of figured, okay, we have to do it ourselves for the time being, if and when there's actual solutions are available. So if you're interested in that, send Jeff or me an email and we can arrange for training for your employees. So this way it's kind of a win-win-win, where we learn what's actually working, what's actually sticking, what solutions are viable, and can pass it forward. We want to make this an ecosystem that protects the agency of humans. What I mean by that, we talk about privacy, and typically privacy is something that people check off when they enter into a website. And it's a checkbox that they don't think about, but it's really about preserving human agency. And we gotten into this scenario by just gross negligence, as in your data, your personal identifiable data stored out there in on average 4,000 databases with as many records. And what this allows companies to do is to social engineer you into whatever corporate objectives are. So Google, for example, is not selling advertising. Google is selling social engineering as a service to the highest bidder. And that's what we want to stop. But we have to start on the individual level. We have to start educating employees at medium-sized companies, because the Googles of the world are not interested in fixing that. The database companies of the world are not interested in fixing that. We talk to them, and that's their business model. And until we address that, our only chance of mitigating damages is to educate your employees.
Yep.
Jeff.
Hey, Chris, we got a question that we didn't answer yet that Colin's going to handle real quick.
Okay.
So just real quick, there was a comment in the chat about the ability to post within a notice that employees should not have an expectation of privacy in the workplace. And I don't know the gist to what that was getting at. While I would certainly agree that you have the ability to do that, and in historical time periods might have been viable to get you out of this, I would not want to rely upon that to get you out of the obligations under the CCPA or CPRA, simply because we haven't seen the way courts will interpret this and whether or not any of the rights therein are in fact waivable. As you know, certain statutory rights you can contract around all day long and others you cannot. And so at this stage, while that may be a viable option, I would think that best practices would say still do it. still do everything you're supposed to until the court says that's a viable contractual provision.
Yeah. Yeah, there are definitely, employees don't have as many rights as they do under a lot of employment law, right? You can contractually get yourself out of a lot of rights through employment law, but it's starting to change. And I would definitely agree with exactly what Colin just said. I wouldn't count on being able to get rid of your privacy rights quite so easily.
All right. With that said, everybody, thanks for joining the call. Thanks for chipping
Christian,
in.
hold on real quick. There was one
There was
question.
another question.
Are
Okay.
the slides going to be shared?
Yes, yeah, we'll share the slide deck with anybody who attended, assuming we have your email address. If we don't have your email address for some reason, ping me or ping Chris, and we'll get it to you.
All right. Well, thanks again, Kim, Colin, Jeff. I'll talk to you later.
Thanks, everybody.
Have a good day.
Thank you,
everybody.
everyone.
Take care.
Good one. Take care. Bye-bye. And Colin ran away. All right.
Nice job, everybody. I think only I fumbled a bit.
You did great.
Well, when I couldn't get my my slides going that second time, I got a little flummoxed.
That happens. Chris is playing with his sounds here.
I was just playing the outro on the recording, actually.
Yeah, and I wasn't smart enough to shut up, was I?
No, that's fine, actually. It's just like you hear like people on TV talking over the outro.
Yeah.
Yeah.
It's fine.
Nice
All
job.
right, gentlemen. I got to run to a work
Yeah,
call. Thank you.
Yeah, let's do this again next month, huh?
Let's do it. If you guys, that vendor piece is critical along with the 4Ds. If you need some materials around that, let me know. Happy to help.
Yeah, that's a good idea. We should add that.
All right.
All right, guys.
Take care, Kim.
Take care. Bye-bye.
Bye.
So we need to send the follow-up email. So only I sent you the list. So only 7 people on the call ultimately.
I think I got a chat from somebody who couldn't get on.
Oh, really?
Yeah, actually, I see one person was late and one person couldn't make it.
Okay.
Or
so
what she couldn't get in.
question is
Tried to attend, but
the
couldn't.
question is if you want to share the recording or not. Thoughts?
Up to you. You want to not send the recording and send them to the next session?
Do you think about that? What are the pros and cons of doing that? How many people would really watch an hour recording like that? Yeah, we should decide that right away because we want to send everybody a follow-up email. And so we either include the link or don't include the link. All right, well, I'm gonna start uploading it to the YBYR channel and we'll take a look, I guess. and see if we feel like looks good. Let's make the decision later today.
Yeah. That's great. All right, buddy. Talk soon.
All right, talk to you later. Bye.
Bye.